right, so I understand the jury's reached a decision. For all the folks that are here, I believe folks weren't here at the end of the first phase of the trial, so I just will repeat myself. I understand this is as intense moment as everybody can have. No matter what the decision is, I don't know what it is. They're back there with the piece of paper. No matter what the decision is, I don't want to hear a sound from anyone. And I know that's a tall task. Why do I say that? I got 12 people here who have been with us since May 31st. They're just trying to do a job. And I don't need them to feel any particular way, one way or the other. I'm going to talk with them. I'll give them the instruction then upon discharge. And once they're out of the courtroom, we'll talk about what the next step is. Okay, it's important that we have them in their actual seats. Okay? All right, let's bring them in. And everybody have a seat. Thank you. So jurors, I understand you've reached a decision. If you could pass that to Deputy Dunkley, please. And then before I look at it, I have a couple of things to talk to you about. So as soon as I finish looking at the verdict, I'll pass it over to the clerk, who will then pronounce it. He will then poll you again, if you remember, ask each and every one of you with specific instructions. And after that, I'm going to be excusing you right to the back. Conclude your jury service. But I want to tell you how much I appreciate your hard work. Some of you have been here since May 31st. This has been a very difficult process, and I admire you and appreciate everything that you've done for us. As you exit, Deputy Dunkley is going to give you a packet, and inside the packet is a letter evidencing your jury work for your employer. If any of you have a problem with your employer, please don't hesitate to call my office, and I'll do whatever I can for you. I've had one problem in 16 years. There's a certificate of appreciation as well. Also, we have your cell phones. Make sure when you go through there that you have your personal belongings from the jury room. But I didn't want to discharge you without just, I can't say it enough, how much I appreciate. You are a very diligent group. Now I have one last instruction for you. So I'm going to read this instruction, then I'm going to look at the verdict form because I want to get you right out. So ladies and gentlemen, I wish to thank you for your time and consideration of this case. I also wish to advise you of some very special privileges enjoyed by jurors. No juror can ever be required to talk about the discussions that occurred in the jury room except by court order. For many centuries, our societies relied upon juries for considerations of difficult cases. We've recognized for hundreds of years that a jury's deliberations, discussions, and votes remain their private affair as long as they wish it. Therefore, the law gives you a unique privilege not to speak about your work. Although you are at liberty to speak with anyone about your deliberations, you are also at liberty to refuse to speak to anyone. A request may come from those who are simply curious or from those who might seek to find fault with you. It will be up to you to decide whether to preserve your privacy as a juror.
Circuit Court of the 15th Judicial Circuit in and for Palm Beach County, Florida, Criminal Division. Case number 17CF002808, A&B, Division X, State of Florida, versus Christopher Vasata, defendant. Verdict. We, the jury, find as follows. As to Christopher Vasata in this case: A, aggravating factors as to count 1, Sean Henry. We, the jury, unanimously find that the state has established beyond a reasonable doubt the existence of the aggravating factor. The first-degree murder was committed in cold, calculated, and premeditated manner, without any pretense of moral or legal justification. Yes. We, the jury, unanimously find that the state has established beyond a reasonable doubt the existence of the aggravating factor. Christopher Vasata was previously convicted of another capital felony or a felony involving the use of violence to another person. Yes. Aggravating factors as account to Brandy L. Sadi. We, the jury, unanimously find that the state has established beyond a reasonable doubt the existence of the aggravating factor. The first-degree murder was committed in cold, calculated, and a premeditated manner, without any pretense or moral or legal justification. No. We, the jury, unanimously find that the state has established beyond a reasonable doubt the existence of the aggravating factor. Christopher Vasata was previously convicted of another capital felony or a felony involving the use of violence to another person. Yes. Aggravating factors as to count 3, Kelly Doherty. We, the jury, unanimously find that the state has established beyond a reasonable doubt the existence of the aggravating factor. The first-degree murder was committed in a cold, calculated, and premeditated manner, without any pretense of moral or legal justification. No. We, the jury, unanimously find that the state has established beyond a reasonable doubt the existence of the aggravating factor. Christopher Vasata was previously convicted of another capital felony or a felony involving the use of violence to another person. Yes. Sufficiency of the aggravating factors as to count 1, Sean Henry. Reviewing the aggravating factors that we unanimously found to be established beyond a reasonable doubt, Section A, we, the jury unanimously find the aggravating factors are sufficient to warrant a possible sentence of death. Yes. The sufficiency of the aggravating factors as to count 2, Brandy L. Sadi. Reviewing the aggravating factors that we unanimously found to be established beyond a reasonable doubt, Section 8, we, the jury, unanimously find the aggravating factors are sufficient to warrant a possible sentence of death. Yes. Sufficiency of the aggravating factors as to count 1, Kelly Doherty. Reviewing the aggravating factors that we unanimously found to be established beyond a reasonable doubt, Section 8, we, the jury, unanimously find the aggravating factors are sufficient to warrant a possible sentence of death. Yes. Mitigating circumstances. One or more individual jurors find that one or more mitigating circumstances was established by the greater weight of the evidence. Yes. Eligibility for the death penalty as for count 1, Sean Henry. We, the jury, unanimously find that the aggravating factors that were proven beyond a reasonable doubt, Section 8, outweigh the mitigating circumstances established. Section C above as to count 1. Yes. Eligibility for the death penalty for count 2, Brandy Al Saeed. We, the jury, unanimously find that the aggravating factors that were proven beyond a reasonable doubt, Section 8, outweigh the mitigating circumstances established. Section C above as to count 2. Yes. Eligibility for the death penalty as to count 3, Kelly Doherty. We, the jury, unanimously find that the aggravating factors that were proven beyond reasonable doubt, Section A, outweigh the mitigating circumstances established. Section C above as to count 3. Yes. Jury verdict as to death penalty for count 1, Sean Henry. Having unanimously found that at least one aggravating factor has been established beyond a reasonable doubt, Section A, that the aggravating factors are sufficient to warrant a sentence of death, Section B, and the aggravating factors outweigh the mitigating circumstances, Section D, we, the jury, unanimously find that Christopher Vasata should be sentenced to death. No. Jury verdict as to the death penalty for count 2, Randy Al-Saeed. Having unanimously found that at least one aggravating factor has been established beyond a reasonable doubt, Section A, that the aggravating factors are sufficient to warrant a sentence of death, Section B, and the aggravating factors outweigh the mitigating circumstances, Section D, we, the jury, unanimously find that Christopher Vasata should be sentenced to death. No. Jury verdict as to death penalty for count 3, Kelly Doherty. Having unanimously found that at least one aggravating factor has been established beyond a reasonable doubt, Section A, that the aggravating factors are sufficient to warrant a sentence of death, Section B, and the aggravating factors outweigh the mitigating circumstances, Section D, we, the jury, unanimously find that Christopher Vasata should be sentenced to death. No. Dated this 27th day of June, 2019, in Palm Beach County, Florida. Signed, jury, 4 persons. Do you, juror number 1, agree that at least one member of the jury voted for a sentence of life imprisonment without the possibility of parole? Yes, sir. Juror number 2, do you agree that at least one member of the jury voted for a sentence of life imprisonment without the possibility of parole? Yes. Juror number 3, do you agree that at least one member of the jury voted for a sentence of life imprisonment without the possibility of parole? Yes. Juror number 4, do you agree that at least one member of the jury voted for a life sentence of life imprisonment without the possibility of parole? Juror number 5, do you agree that at least one member of the jury voted for a sentence of life imprisonment without the possibility of parole? Yes. Juror number 6, do you agree that at least one member of the jury voted for a sentence of life imprisonment without the possibility of parole? Yes. Juror number 7, do you agree that at least one member of the jury voted for a sentence of life imprisonment without the possibility of parole? Yes. Juror number 8, do you agree that at least one member of the jury voted for a sentence of life imprisonment without the possibility of parole? Yes. Juror number 9, do you agree that at least one member of the jury voted for a sentence of life imprisonment without the possibility of parole? Yes. Juror number 10, do you agree that at least one member of the jury voted for a sentence of life imprisonment without the possibility of parole? Yes. Juror number 11, do you agree that at least one member of the jury voted for a sentence of life imprisonment without the possibility of parole? Juror number 12, do you agree that at least one member of the jury voted for a sentence of life imprisonment without the possibility of parole?
Thank you. You're excused. All right, everybody have a seat. State, I plan on ending this right now. There's no reason for me to set anything off, am I correct? Okay. Defense, same? Okay. So it's pretty straightforward. On the 3 counts of first-degree murder, I sentenced the defendant to life imprisonment without the possibility of parole. There is the count of grand theft auto, which is a third-degree felon. I hereby sentence him to 5 years in the Department of Corrections on that count, and the attempted first-degree murder of Charles Vorpagel, I sentence him to life imprisonment as well. You won't look like you're about to tell me something, Steve.
They all run consecutively.
And they all run consecutively. I'm not so sure. And I give life.
And we will no cross the possession of the firearm.
Okay.
Did you say you're running the counts consecutively?
Correct. I'm not so sure it makes a difference when it's life without the possibility of parole, but I am. And there's court costs I must announce on the record. Seems trivial. $1,120. Damien, are you satisfied?
Counts 1, 2, and 3, mandatory life.
Correct.
All counts consecutive.
Correct.
Jail credit
When we recess, I'll have the lawyers calculate that for me. Sometimes at this juncture, the judge says all sorts of things, and I'm going to say very little. I have a lot of personal feelings about what's happened here, and I'm not so sure there's anything I can say that would make the victim's family feel any better. Additionally, I don't think there's anything I can say to the defendant who's being sentenced to life imprisonment without the possibility of parole that it's anything he wants to hear as well. And then lastly, I have a co-defendant case that I don't want any of my comments to be construed that I wouldn't be fair. So I'm going to stay quiet. It doesn't mean I don't have a lot of personal feelings about what took place in this courtroom since May 31st. Thank you for everybody being so courteous to me, everybody in the courtroom, all the lawyers. We're in recess. Can you be with me in the morning? Yes. That's going to be our change
For now, I know. Of course. Get a breather, get back together. Bye, guys.
Hi.